Well, good afternoon, everyone, and welcome to our seminar here today. Julie and I are so thankful that you're taking time out of your busy day to spend with us as we give you some tips on how to customize your trust to make it the perfect fit for your estate plan. So we are about to cover a tremendous amount of information over the next hour or so. And if you think of any questions at any point in time throughout this seminar, feel free to jot those down. And Julie and I are going to try to save some time at the end to answer any questions that you might think of as we go over everything. So over the next hour, we're going to take a really deep dive into all things trust. Just a couple of the things that we're going to talk about today is how assets are managed once they're put into a trust. We're going to help you identify the main players associated with your trust. So then you can start to think of who you want to assign to those roles and the best way for you to execute your decisions regarding how you want your trust to work. We're going to talk about who holds the key to unlocking the trust, who can access the property that's in a trust after you put it in there. And we're also going to talk a little bit about how you can use a trust in your long-term care planning. So as we were getting ready for the seminar today, we really designed this for those of you who have any of these concerns or questions that we have up here. So if you are unsure of how you want to incorporate a trust into your estate plan, what's the best trust for you? If you have any concerns about possibly losing everything you have to a nursing home, and if you want to make sure that you're doing everything that you can to put yourself and your family in control of your assets and your estate for the second half of your life. If you resonate with any of these things, then you are in the right place today. This seminar is for you. And let me tell you, you're absolutely not alone. Julie and I meet with clients all day, every day who have these same exact concerns, these same questions. And what we're able to do is really work with you, work with our clients to figure out the best possible estate plan for you to put you and your family in the best situation you can be in for the second half of your life. But before we get into a little bit more of the details of how exactly we do that and some different things for you to be thinking about for that process, we're going to take a moment just to pause and introduce ourselves a little bit more.
Fantastic. Thanks so much, Megan. So as Kyle said, I am the founding shareholder of Steinbacher, Goodall, and Yurchak. I am a certified elder law attorney. And so that means that I went through additional programming and took a test that was very specific to this area of the law and was able to say that I'm certified as an elder law attorney. I also have an LLM in estate and elder law, and that's an additional education. But day to day at the firm, I can work in any of the offices, primarily in the Williamsport office. But the firm really has my vision of focusing on long-term care planning, nursing home, Alzheimer's, dementia. We also deal with a lot of high-end taxes and business planning. And interestingly, the foundation to so much of this is our knowledge about trust and using trust to achieve different goals for people moving forward. And that's what we're going to talk to you about today. I'm also an author of many books, and actually at the end of the day, we'll have an offer if you want to get a copy of these books. But what you really need to know for the second half of life, I've also written a book about Alzheimer's and dementia and how to protect your family. So I think it's really important that part of what we do as a law firm is to help you educate yourself about what it is you want for your own plan and how any of these tools that we use can help you achieve those goals. I am also a member of ACTEC, and there's, again, very few attorneys in the state of Pennsylvania that are chosen to be part of the American College of Trust and Estate Fellows. Recognized as a super lawyer, a superb rating on AVVO, and have presented a TED Talk. The nice thing for me is that I really love what I do, and that comes through because I'm so committed to all areas of it and learning how to do it better and better. Although I have to admit the technology part of it is not something I'm excited about. Much more excited about trust law and tax than I am about all the things I've had to learn during COVID.
Yeah, I think that's very fair, Julie. Thank you. Thank you. I completely agree. Yes, as Kyle already mentioned, my name is Megan. I am also one of the attorneys here at our office. I primarily work out of our state college and our Williamsport offices. And I am also a certified dementia practitioner. So that means I went through some extra training to learn the best ways to assist our clients who have dementia diagnoses. I graduated summa cum laude from Penn State Law in 2020. And during my time in law school, I concentrated most of my studies in tax law. I also, during my time in law school, was able to earn a couple of awards for earning the highest final grade in 8 different classes that I took, including my Wills Trust and Estates class. So before law school, I graduated from the College of Business at Penn State with a degree in finance and a minor in business law. And while I was in school, I actually spent quite a few years working here at the firm as a legal assistant. And I jumped around to a couple different departments, trying to get my feet wet in a lot of different areas, and really tried as best I could to soak up every little ounce of knowledge that I could before I eventually graduated and passed the bar myself. Whenever I'm not working, this little guy takes up all of my time. This is my son, Jonathan. He is 6 months old now, and he is growing like a bad week. I cannot believe how much he's grown over the past 6 months and how much the time has flown by. I also have up here my golden doodle. Her name is Poppy. And you can tell by this picture that Poppy's a pretty smart dog. She's already figured out the best place she can be is right underneath Jonathan's high chair, ready to catch any piece of food that might come her way. She's already figured it out pretty well. So one of the questions that I get a lot is how I ended up in this profession. Because as you can probably imagine, elder law is not a really popular area for young attorneys fresh out of law school to get excited about. But I've actually known that I wanted to be an elder law attorney since I was 14 years old. And that's because of an experience that I went through with my grandfather, who you can see here. So my dad passed away about 12 years ago now, and he developed dementia later on in life. And unfortunately, his dementia progressed to the point where he was taken advantage of by someone. And it was actually was so bad that my family ended up having to hire one of the elder law attorneys here at Steinbacher, Goodall, and Yurchak to try to rectify that damage and try to restore things to how they were beforehand. And as painful and as difficult as that time was for my family, we are thankful that we have the opportunity to see the silver lining of all of that, which is here I am now as an elder law attorney at the same exact law firm that we turn to for help. And now I'm able to help other families who might be in similar situations. So with that covered, let's talk about trust. So our game plan for today is I am going to get us started with just a general overview about trust and how they work before Julie and I dive into the 3 tips for how you can customize your trust to make it the best fit for you. First things first, what is a trust? Well, a trust is a distinct legal entity. It's separate from yourself. It's a distinct legal entity that is able to own property. And the trust document that you sign, that is really just the written set of rules saying what you can and cannot do with the property that the trust owns. That's how that works. And in that written document, we're going to make sure that we're going to cover a set list of things. Of course, we're going to want to list who the beneficiaries are, who has the right to enjoy and use the property that the trust owns. That document is also going to name the trustee. The trustee is the person who has to manage the property that is owned by the trust. The document might also list a trust protector, and that's a person who has the ability to pull property out of the trust if we would need them to. And we're definitely going to want to list the powers of the trustee and the trust protector. We're going to want to spell out what they can and cannot do while they're doing things on behalf of the trust. The trust is also going to cover taxes. How is the property in the trust taxed? Who pays that tax? And I know later on, Julie is going to give us a really in-depth look into the taxes surrounding trust. And last but not least, we're going to want to make sure that your trust has a spendthrift clause. Now, spendthrift clause is a paragraph that says, any creditors that the beneficiaries have, those creditors cannot access the property that the trust holds while it's in the trust. That's a great way to give your beneficiary some protection. So there are a lot of different kinds of trusts out there. But I think all the different kinds of trusts can really be broken down into 2 general categories. There are revocable trusts and irrevocable trust. So a revocable trust, as you can tell by the name, it's revocable. You can change it, you can get rid of it really easily whenever you want. You also have direct access to any property that a revocable trust owns. But because you have access to the trust property, so do your creditors, including the nursing home. So if your goal is to try to protect your assets from the cost of your long-term care, a revocable trust is probably not going to be the best choice for you to accomplish that goal. On the other hand, we also have irrevocable trust. And as you can guess, an irrevocable trust, it's much harder to make changes to those, to get rid of them if you would change your mind about it later at some point. And you also don't have direct access to the property that the trust owns in an irrevocable trust. But because you're not able to reach your hand into that trust and pull out property whenever you want, neither can the nursing home, neither can your creditors. So if our goal for you is to try to protect your assets from the cost of your long-term care, the irrevocable trust is really going to be a better option for you to accomplish that goal. I think there is a common misconception out there maybe that trusts are just for rich people. And that is absolutely not true. As I said, there are so many different kinds of trusts out there that do different things. And so there's a lot of different reasons why we might recommend that you include a trust in your estate plan. We've listed just a couple examples of that here. One example is maybe one of your beneficiaries is disabled. And so that beneficiary might be receiving some kind of government benefits or might start to receive government benefits in the future. We might have some concerns that if that beneficiary receives an inheritance from you outright, then suddenly they might have too many assets to qualify for those benefits. It might be a better option to give that inheritance to your beneficiary in a trust instead. Or a lot of times, another reason why we use trust is because you might want to spread out the inheritance to your beneficiary so that they receive it over a period of time instead of just receiving one lump sum whenever you pass away. That's another thing that we can do with trust. But by far, the most common reason why we use trust, the most often why we recommend a trust for your estate plan is because you want to try to protect your assets from the cost of your long-term care. And in that scenario, like I mentioned already, that's whenever we're going to be looking at the irrevocable asset protection trust. And the reason why those irrevocable trusts are so beneficial to try to protect your assets from the cost of your care is because those irrevocable trusts allow us to transfer your property into the trust in a way that you can still maintain some level of control over those assets while we're still protecting them from your creditors and from your long-term care costs. So as I mentioned, some of the advantages of using these irrevocable trusts is any assets that the irrevocable trust owns, it's not subject to the cost of your long-term care. So that's a way to protect your assets from the cost of your care during your life. Additionally, if you end up qualifying for Medicaid, which many of our clients come to us and they're trying to set up their estate in a way so that they eventually qualify for Medicaid benefits, and so they can help use those Medicaid benefits to help pay for their long-term care later in life. And again, that's something that Julie is going to talk about in more detail for us later on. But if you end up qualifying for Medicaid and Medicaid helps cover some of the costs of your long-term care, then after you pass away, the state is able to try to reimburse itself from the cost it's spent on your care during your life by trying to recover some of the assets of your estate. But if assets are held in an irrevocable asset protection trust, the state is not allowed to recover those assets to reimburse itself from your care. So just like how using these asset protection trusts allows us to protect your assets from the cost of your long-term care during your life, we also have that protection after you pass away, that the state's not allowed to recover those assets if you end up qualifying for Medicaid. Finally, another huge advantage of the irrevocable trust is that it's not subject to what we call the 4 Ds. And this is the divorce, debt, disability, or death of the beneficiaries of this trust. Julie and I have a lot of clients who come in and they ask, can I gift my house to my kids for $1? Or I want to start giving my money to my kids now so that it's out of my name and the nursing home can't take it whenever I need care. And, of course, gifting your house, gifting your assets, that is one way to get those things out of your estate. But then there are a lot of concerns that we are thinking of in that scenario. Gifting right to your kids is usually not the best course of action, our top recommendation for you. And that's because for example, if you gift your house to your children for $1, then your children own your house now. You don't own it. Or if your child is in a car accident and ends up getting sued, then your house or any other property that you gifted to them could be subject to be recovered from any judgment that's rendered against them. or heaven forbid your children pass away before you do, then your house and any other assets you gifted to them is going to pass according to their last will and testament and onto their beneficiaries. So those are all things that we need to think about whenever we're thinking about gifting to your kids. But those aren't concerns that we would necessarily have with an asset protection trust. We don't have to have those same concerns if you transfer your assets to a trust instead. Some additional benefits of these trusts is any property that is owned by the trust whenever you pass away, it avoids probate. So you don't have to go through that process with the trust assets. And the trust also gives you a mechanism for managing these assets upon your death. So again, these are all just some benefits to using these asset protection trusts to protect your assets from some of the costs of your care. That brings us to our trust tackle tip number 1, which is to set your lineup. Who are the players going to be? First things first, you need to figure out who you want to be involved in your trust and what their roles are going to be within your trust. First up in our lineup is the donor. The donor is the person who creates the trust. This is probably going to be you. So whenever you create the trust, you're the donor, you get to set the rules of the game. You get to set the rules that are laid out in the trust document, what everyone is and is not allowed to do with the property in the trust. And you also get to choose what property is going to be transferred into the trust. You get to choose what is going to be going into the trust, how that is going to be funded. Another person in our lineup is the trustee. Like I touched on before, this is the person who is going to manage the assets once they're transferred into the trust. And this could also be you. The donor is able to serve as the trustee. So it's possible for you to set up a trust, figure out what rules you want to apply to that trust, what property you want that trust to own, and then you can continue to serve as the trustee. So you can continue to manage that property, continue to manage those assets that were yours, even though they're now in the trust. Some of the other things that a trustee has a responsibility of doing is to pay any of the expenses associated with the maintenance or the upkeep with any property that the trust owns. And it's possible that this could involve the trustee opening up a bank account that's in the name of the trust, and then using the money from the trust bank account to pay for the expenses associated with maintaining the trust property. And the trustee is also the person who gets to make the investment decisions with the trust property. How's that property going to be invested? The trustee can choose what kind of account they want to use to invest that money in the trust. They can choose what bank or what financial institution they want to use. The trustee has the option of managing those investments themselves, being the person who oversees that, or they could hire a financial professional like a bank or financial advisor to manage those investments on behalf of the trust. That's all within the trustee's discretion, what they think would be in the best interest of the trust and the beneficiaries of the trust. Next up in our lineup is the trust protector. And the trust protector is a role that is unique to those irrevocable asset protection trusts that we were talking about. So as I mentioned before, with an irrevocable trust, you don't have direct access to the property that's in the trust. You're not able to reach in and pull property out of the trust whenever you want. But we build a back door into those trusts. And the trust protector is the person who's holding the key to unlock that back door. The trust protector is a person that you can designate. It can't be you. You can't serve as the trust protector, but it's someone else that you choose who is authorized to pull property out of the trust if we would need them to, and give it to the beneficiaries of the trust. Now, like I mentioned before, the part of the irrevocable asset protection trust that protects it from the cost of your long-term care is the fact that you don't have access to the property in an irrevocable trust. And so for that reason, to maintain that protection, it's important that your trust protector isn't allowed to pull property out of the trust and then give it to you, because then once you have access to the money that was in the trust, then it's available to pay for your long-term care and it's not protected anymore. But the trust protector can pull property out of the trust and give it to the beneficiaries of the trust. And then the intention, the design of this is that once the beneficiaries get that money that was in the trust, that the beneficiaries would then use that money to pay for things on your behalf. They would buy things for you. They would pay for services for you. So that is sort of a mechanism, a way that we have designed so that you're still able to benefit from the property that you put into the trust if you end up needing that property that is in the trust, while still giving you those same kinds of restrictions that give it protection from the cost of your long-term care. Now, of course, like as you can see, this is giving the trust protector and the beneficiaries a lot of power. You're really relying on them to do what you want them to do and to carry this out. And so there are a couple safety nets there to make sure that the trust protectors and the beneficiaries are going to do what you would like them to do in this scenario. If you see that the trust protectors aren't doing what you would like, then you could always fire them. You know, in our trust, we built in that you can always remove the trust protectors from that position if they're not doing something the way that you would like them to be doing it. You can remove them from that position, appoint someone else into that position instead. Or it's possible that we might be able to do an administrative amendment to the trust to make some kind of adjustments to the beneficiaries if we would need to. So those are just a couple of options that we might be able to look into if you have any concerns about the trust protector or the beneficiary not following your wishes with how you would like the trust property to be used after you transfer it into the trust. So that is the end of our lineup. Those are all of the people involved in the trust. And those are all the people that you need to start making decisions of who should be filling those roles. But one last thing that you should also be thinking about whenever we're talking about drafting the trust document, one other thing you want to include in the rules of this game is when the beneficiaries get the property that's in the trust. Some different options are maybe you would like the trust to terminate whenever you pass away. And so whenever you pass away, the trust is finished then, and any property that the trust owns is paid out to your beneficiaries at that time. Or maybe you want the trust to continue on after your death. Do you want the assets to continue to be held in trust into the future? And so the rules of the trust are still going to apply to those assets in the future. That's another decision that you can make and another tool that you can use to customize this trust to make it the best fit for you. So our second trust tackle tip is to think about what assets you want your trust to own. Figure out what you want to transfer into the trust. There are a lot of different things that we can transfer into your trust. We've listed just a couple of them here. Real estate is by far the most common thing that we transfer into a trust. That's something that we often do for our clients. We can also transfer your investment accounts, or if you have any annuities, bonds, any bank accounts that you might want to put into a trust, life insurance. These are all examples of different things that we can put into your trust. Now, whenever I say that we're going to be transferring property into the trust, how that process actually takes place is we are actually changing the owner of these assets. So we are removing you as an owner and making the trust an owner. If you want to put real estate into the trust, that means that we're going to be doing a new deed from yourself to your trust as the new owner of that property. If you want to put an investment account into your trust, then that means we are removing your name from that investment account and putting the name of your trust as the owner of that investment account. We also might be able to update the beneficiaries. We might be able to make the trust a beneficiary of some of your assets. Those are just another way that we can really incorporate this trust into your estate and figure out the best way to use this trust depending on what assets you personally have. But there are some restrictions on what we can put into your trust. There's a couple of things that we're not going to be able to. Retirement accounts are one of the things that we're not going to be able to transfer into a trust. Because whenever we would try to change the owner of a retirement account from your name into the name of a trust, we could trigger a lot of tax consequences that we would want to avoid. So a retirement account is one thing that we're not able to transfer into a trust during your life. We might be able to make a trust one of the beneficiaries of the retirement accounts. That's one way we can incorporate a trust into your retirement accounts, but we can't put it in during your life. Also in Pennsylvania, we're not able to transfer vehicles or any mobile homes into account. So there are a few restrictions on some of the things that your trust can own. But ultimately, as you're weighing what you want to put into your trust, you really have to think of the pros and cons regarding each particular asset that you own. As we've already talked about today, some of the big pros is what if you decide to go with an irrevocable protector trust, then the property that you put into the trust then is not subject to the cost of your long-term care, your nursing home costs during your life. And that property is also protected from the estate recovery lien. If you end up qualifying for Medicaid and Medicaid pays some of the costs of your long-term care, the property in the trust cannot be recovered by Pennsylvania to try to reimburse itself from the cost of your care after you pass away. Also, as I mentioned, the property in the trust is protected from the 4 Ds of your beneficiaries: their divorce, debt, disability, or death. And again, any property you put into a trust, another benefit is we get to avoid the probate process. And you also have some control over how that property might be managed after your death. All good things to think about when determining what could be good choices to put into your trust. But again, another thing to consider is with those irrevocable protector trusts, you're not going to have direct access to the property after you put it into the trust. So that's a big thing to think about when you're weighing, is this asset something that I want to put into my trust? Is this something that I really need to access a lot, like a checking account that I use to pay my bills regularly, like my operating account? Those kinds of things might not be the best option to put into an irrevocable trust. So those are just some of the things to consider whenever you're figuring out the best way to organize your estate and your assets into a trust. So that brings us to our third and final trust tackle tip, which Julie is going to cover for us.
Yeah, fantastic job, Megan. And if you guys thought trust law was exciting, wait till we get to the tax part. So we are going to talk about how taxes affect trusts. And this is a really important topic because there is definitely a lot of misconceptions here. And so we're going to try to walk through this and talk about different types of taxes and how they affect trusts. So first, as a foundational question that we always have to ask ourselves is the trust a grantor trust or a non-grantor? Now, typically, I wouldn't want to be on here talking a lot of tax stuff, but this is really important because most of the trusts that we do at our office are grantor trusts. And that means that when I set up the trust for you, we can still just use your Social Security number. All the trust income can be reported back on your tax return. And that means it's your lower personal. It also means that when somebody passes away and it goes to the next generation, we're going to get what's called a step up in basis. And that means that if you turn around and sell it, like it's stock or real estate, you're not going to pay capital gains tax. Would be subject to Pennsylvania inheritance tax. Now, I just went through all of that really quickly. But I want people to know that most of the time, if you were to come to me and I would suggest that you would do a trust and you would talk to somebody about it, they would say, oh, you don't want to do that because there's, these extra taxes, you pay higher rates. When they're saying that, they're talking about non-grantor trusts. I would even say to you that with a non-grantor trust, we are able to mitigate some of those issues. But that's when we get like an employer identification number. It's like its own entity. It will be taxed at a higher rate, but we can push it through to beneficiaries. We're going to make it so that it's a completed gift maybe, and then we don't pay inheritance tax, but we don't get that stepped up basis. So there's reasons, but what I want everybody on here to know is that don't just have somebody tell you shouldn't do a trust because of taxation issues. That is very, very much about the type of trust we do. And if we go back to thinking about those grantor trusts that we usually use, what's going to happen with them is there actually is not any adverse tax consequence. The IRS really says if you have a grantor trust, you as the grantor, it's just as if you still owned it. And so let's, not start the conversation where, oh, we shouldn't do this because. Now, we do sometimes use non-grantor trusts, and there is a little bit difficulty with the taxation, but often we're avoiding an even worse tax, and that's why we're doing it. And so we always want to make sure that people understand that. So let's talk about Pennsylvania inheritance taxes. So this is not just trust. These are the general rates for anybody. Okay, and I'm going to go through this. Now, when I use a grantor trust, typically, I'm still going to be subject to these inheritance tax rates. And if I use a non-grantor trust, sometimes I'm not going to be. But remember, I missed the step up in basis. So I had said that I had went through that quickly. And what I want to do is kind of pick up with a scenario for you so that you understand. So let's say I had a house and I put it in a trust, and that was a grantor trust, and the person died, okay? And everything went to their children. Well, if we look at the PowerPoint, we see the charts. That means we're going to pay inheritance tax. And so the rates to a spouse or a child under the age of 21 is 0. So interestingly, when I first became an attorney, there used to be tax between spouses. There actually was until 1993 in Pennsylvania. But 4.5% to direct descendants or lineal heirs, such your children, grandchildren, those types of people. 12% to siblings, and 15% to anybody else, which includes nieces and nephews, which is probably the hardest part of this in my situation, where I think, wow, they're not treated any different than the mailman, it's all the same taxation rate. So again, if I put my house in a trust and I pass away, my children are going to pay the 4.5% inheritance tax, but they're going to get a step up in basis. And what that means is that when they sell it, they're not going to have to pay capital gains tax. And in the majority of situations, the capital gains tax would be more than the inheritance tax was. It's not going to be true if you just bought the house recently, but most of our clients that we're dealing with have had their house for quite some time. Opposite is true maybe with a non-grantor trust, where like we give up all control. We put some real estate in there. We don't pay the inheritance tax. But then when we sell it, we're going to have to pay a lot more capital gains tax. So again, whenever you work with an attorney or anything on this, make sure that they understand the taxation issues and not just one part of the taxes, but more. So again, this inheritance tax is assessed on assets when you pass away, for those people that inherited. In Pennsylvania, it taxes $1. So if you die with, $1 and it goes to your kid, the state wants 4.5 cents of that. Really, they probably do, to be honest with you, but that's how it works. Now, the 2% realty transfer tax in here is not when somebody dies, but we have to think about this whenever we put things into trust. So anytime you buy any piece of real estate, there's a 2% inheritance tax. And most times we don't think about it much, because when we buy a house, usually right on the HUD, like right when you buy it, 1% is paid by the buyer and 1% is paid by the seller. But it doesn't matter if we're actually making a sale or if we're just transferring it. This is for any real estate that transfers, there's a 2% tax. Most times we're not paying that when we do our estate planning, because there's an exemption for family members. So if I pass away, or I don't pass away, I just give my house to my child, that's not subject to the 2% realty transfer tax, because my child is an exempt person. When we go into trust, it does get more complicated, and we have to worry about who all could possibly be a beneficiary, not just who's the first line of beneficiaries. And there's some complication in there that stepchildren are exempt, but step grandchildren aren't. And so when we put together a trust, we always have to work through those things. But these are some taxes to consider. First, the inheritance tax, and then the realty transfer tax. Before we go on to the next slide, though, I want to point out to people that most times people come to me, they want to avoid the inheritance tax. And based on what I said, many times that's actually a little bit short-sighted. And so we want to think about that. But let's look at more taxes. The federal transfer taxes. This is the tax that most people know about, but it actually doesn't apply to that many people right now. Now, when I started as an attorney, so I don't know if you guys noticed, Megan told you when she graduated. I did not, because I graduated a long time ago, and I'd rather not let you know how old I am. But when I first became an attorney, the exemption was only $600,000. And so anybody who died with more money than that had to pay a federal estate tax. And that includes all your real estate. It includes life insurance, includes anything that you have. And so it was pretty easy for people to get above the $600,000. And this tax could be 45, 50%. So not the 4.5% I talked about with Pennsylvania. This is federal, 45 to 50%. So obviously we would try to do things to avoid that. And people still know about this. Often when politically they're raising the exemption or turning it down, people are often really, have opinions about that. Like, should this tax exist? But for most of you, what you need to know is that unless you have 12,600,000, and I would guess that most people on here don't, that you don't have to worry about that tax. Now, we may worry if you came and met with Megan or I about your estate work, we might worry about it even if you had a lot less than that, because there's been a move to reduce that 12,600,000 back down to maybe 6 or 7 million. And we don't know what's going to happen with that, but there was pending legislation that had moved it down. There was talk within the budgets to move that down. And so it will likely move down. With spousal portability, though, for those of you who are married, you would still get double. So federal estate taxes are a big tax, still 45, 50%, but doesn't affect a huge amount of people. As far as the federal gift tax, now I get this question a lot. Can I give money to my children, or do I have to pay a tax on it, or do they? So the exclusion used to be for many, many years, it was $10,000. A lot of people knew that. They knew they could give away $10,000 without any consequence. For most people, even if you went above $10,000, which is now 16, there isn't much of a consequence either, besides that you have to report it. So let's say I gave away my house. Let's say I took my house, I put it in a trust. I totally made it a non-grantor trust, and it was a completed gift and I didn't have any control over it. I would have to fill out a gift tax return and tell the federal government that I had given away more than $16,000 a year to one person. And what they would do is they would start to deduct some of my coupon, in this situation, the $12,600,000, so that what I give away during life and at death can't be over that. Most people who come into my office, they're concerned about this exclusion. And most people, I say, it's okay, you don't have to worry about it. The bigger issue for most people is what Megan talked about and alluded to, and we're going to get more into, which is what happens if I need nursing home care. What if I've given a gift away and then I'm in a nursing home, or I need in-home care and I need to get some help with the government for that. So income taxes. So again, federal income taxes, if I have a grantor trust, it's the same as if I owned it myself. But there are different thresholds if I have a non-grantor trust. And it is true that those thresholds, those amounts that are taxed, the tax rates go up very quickly. If we have situations like that, what we do is we distribute it out to a beneficiary, and then the beneficiary will pay the tax. For state income taxes, it's the same. The bottom line with all of this is you have to pay the tax someplace. So there used to be a lot of scams out there that said if you put your money into a trust, you don't have to pay the state income tax. That is a scam. If it was that easy, we would be doing it for everybody. That is not true. And some places will still try to do scams, tell you if you go to a different state and put your trust there, you don't have to pay state income taxes. Pennsylvania is not very happy with things like that. So, if you live in Pennsylvania, you're a resident of Pennsylvania, and you have real estate here, or you have money here, and it makes income, if you put it in the trust, either you have to pay the tax or the trust does. And that can depend on what the trust is, but never would it make it so that it's not taxable. Unless you totally gave up control, but then it's taxable to somebody else. There's always going to be a beneficiary, always going to be someplace where we're paying taxes. So don't buy into some of those people that tell you that this is a way to avoid taxation. It's not. Income taxes are due on the growth of your money every year. The only way that you get any deduction or kind of relief from that is if we use something called a charitable trust. And there are clients that we do that for, but not many people. But we do charitable lead, charitable remainders, and then we can get some, but that's because there's a charitable deduction. So it's still subject to the tax, but we're being able to deduct it because ultimately we're benefiting a charity. So when we think about estate and trust administrations, I'm kind of here switching a little bit to not setting up the trust, which is what Megan talked about, to now I have this and I pass away. So we have to think about, when I pass away, do I want a will or do I want a trust? And what's the difference? So again, sometimes people are told if you put your money in a trust, you won't pay inheritance tax. That is not necessarily true. We have to know what the trust says. And again, if we're doing a grant or trust where you still have a lot of control, you're gonna pay the inheritance tax. So it's not going to be higher or lower, whether it's a will or a trust. Now, I do some trusts where they're completed gifts and we avoid the inheritance tax. But again, I might be losing a step up in basis, those capital gains. And so I don't do that a lot. With the will, there is a probate fee, and that is getting higher and higher in Pennsylvania. And so sometimes we really like to do trusts because anything that goes through there, we don't have to pay that probate fee. The attorney's fees can be similar, but it depends on the law office, to be honest with you. At our office, people end up paying less money, partly because they're more organized, to be honest with you. They've thought through what everything is. We've really spent some time making sure it goes to the beneficiary in the simplest, most tax advantage manner possible, so we don't have to do as much paperwork. So generally, attorney's fees with trusts are going to be less. But again, that's going to be up to the individual law office and what needs to be done. Some people use just a percentage, and then the trust fees are less. But some people look at the work to be done, and some people, at our office, our goal when we're planning your estate is to make it so that your estate fees are less because you're organized. And that's also helpful. It's not just a money issue. That is also helpful because it's less for your children to do. Last year, the beneficiary can contest, and that is true. So it is easier for a will to be contested than a trust. That is 100% true. And this is talking about considering an in territorium clause. That's a clause that you put in a will that says, if anybody contests this, they give up the right to any inheritance. So if they contest it and lose, they gave up everything. But I would say to you that because a will is implemented when somebody dies, people can try to set it aside or claim against it easier. Because a trust is set up during somebody's life, it's harder for somebody to stop that. And that's really important. If you have a difficult family situation, maybe where you want your money to go isn't the natural way, or maybe different people in your family have different opinions about where it should go. In those situations, we definitely want to use a trust. And I just want to talk, everybody, you are very, very welcome to unmute yourself and ask questions. I know we're going to take questions at the end, but also you can put them in the chat. And you can do that now, or you can wait until the end. But I just want to remind everybody that, Megan and I are here today. We appreciate your time, and we want to make sure that we're able to answer questions if you have any. So the trust administration after death, it is a probate-like process. So in Pennsylvania, there's a lot of the same things. Like we have to send notices to the beneficiaries. We might still be doing an inheritance tax return. We might be still advertising it in the paper. So it's not correct for people to say you don't have to do anything. And I know some people say that. They say, oh, do a trust, and then when you die, your kids won't have to do anything. That has not been the law in Pennsylvania since 2006. In 2006, we implemented the uniform trust code, and it makes it very similar, but slightly less. And so less that we have to interact with the courts. We don't have to, if somebody passes away, we immediately have money, and that's really important. We were reminded of that during COVID. So when COVID hit, Every county was different. We had counties like Center County in the State College area, where when COVID hit, we did not miss a beat. If somebody passed away, we were able to, via Zoom, probate estates. We were able to continue moving forward with our business, never stopped. We have other counties like Lycoming County, where for 8 weeks we weren't able to do anything. And that was hard, because if your loved one passed away and we needed to get up money, we actually couldn't, to pay rent, to pay. I remember I had this one that we really needed to get to the money to pay a car payment. And I kept calling the car payment company, and they didn't care that we couldn't get to the money. And so that's a great reason to use a trust, because we did not need to interact with the courts. So even though the trust administration is a probate-like process, it doesn't require us to interact with the court system. So that's important. And I always try to be really fair, because, you know, sometimes people oversell and say, oh, you don't have to do anything. You do. It's just less. There's still great value, but to think that I didn't have to do anything when somebody passes away with a trust is just not accurate.
Julie?
Yes.
Question in the chat. If you leave assets to a sibling that lives in Florida, would you still pay the 12% tax to PA, or would Florida tax it?
So if you're a resident of Pennsylvania, that's a great question. If you're a resident of Pennsylvania, it would still be the 12% to Pennsylvania. It doesn't matter where the person lives that receives it. It's whether or not you're a Pennsylvania resident. Great. So trust and levels of care. So one of the reasons that we use trust is to protect assets from the cost of long-term care. So I get sick and I need to go into a nursing home, or I need in-home care, and I want to be able to access some of those benefits while still protecting money for my spouse or my loved ones. One of the questions that people always say, well, if I do those types of things, will it limit my options or level of services? You will have to move into a facility that accepts Medicaid, and that is not a bad thing in North Central Pennsylvania. Most of the facilities that are nursing homes do accept that level of care, and they have very good care. We're actually really lucky in Pennsylvania that our government actually reimburses the facilities at a very high level, higher than other states, and that does allow us to have quality of care. Now, the issue is, though, that not all levels of care are paid for. So just to give you an example of that, when we think about somebody who maybe has dementia and they need dementia unit, that may not be in a nursing home, and they may not get medical assistance. So that's sometimes what families have to confront. They have an option over here that is a good option, a Medicaid bed in a nursing home, but it may not be specialized into dementia, and there might be a dementia unit that does not accept medical assistance, that is a better place for somebody to receive care given their specialized needs. We confronted that actually in my father-in-law's situation, and we ended up making the decision to go to the place that did not receive medical assistance, but was a better care option for him. So we think about Medicaid. So what I'm talking about is I take assets, and Megan told us why I wouldn't just give them to my kids, because I don't know, would they get divorced? Would they die? Would they become bankrupt? Would they become disabled? All things that if you have good kids can happen. So I would take it and I'd put it into a trust. And the issue is when we think about Medicaid helping to pay for care, both in-home care and nursing home care, there is a look back. So if I take my assets and I put it into a trust, Medicaid's going to say, hey, have you given anything away in the last 5 years? And if you have, you've taken assets and you put them in the trust, you have to let them know that. And that's why it's really important that we're able to do this before somebody's sick. Now, if somebody is sick, there might still be things we can do, but generally we want to do that ahead of time. If people gifted assets to either individuals outright, children, or to a trust within 5 years, Medicaid can deny that application, and then they're going to oppose the penalty period. So we're going to talk about, well, how is that penalty period determined? They actually take the average cost of nursing home care in the state, and they give a 1-month penalty for each month that happens. Interestingly here, the average cost of nursing home care in the state of Pennsylvania for 2022 is $14,676.04. Now, if you're not floored by that, I think you should be, because I'm still floored by it. Last year, the average cost of care was about $11,000. When I became an attorney, it was $2,000. I have never known it to go up so much, but last year it went up from $11,000 to $14,676. Again, I would say to you guys, it's good that it's high, because that's how our state reimburses our facilities and why we in Pennsylvania actually have some pretty good care compared to other states. I was just at a conference in Tempe, Arizona, and talking to people from other states, such as like California, where their state does not reimburse really well, and they have huge issues with quality of care. It's also important when you think about where, if you decided to retire someplace else, it's really important to see what type of care they have and how these rules apply. But back to the penalty period. So it's $14,676.04. So how do we figure it out? So let's decide that in this scenario, you give away $200,000 to a trust. So you have $200,000 in the bank, you give it to the trust, it's still in the bank, still like a CD or whatever it is. But the state of Pennsylvania is going to say, we're going to take the $200,000 that you gave away and divide it by the average cost of nursing home care, that $14,676. And if I got out my little calculator or did it in my head, I would come out with 14 months. So 14,676 times 14 is $200,000. And that means that the state's going to say, we're not going to allow you to pay for any nursing home care for 14 months. So if, let's say, we transfer $200,000 of property in November of 2018, and they go into the nursing home November of 2022, the 5-year look back doesn't expire until November of 2023. So it's 5 years from November of 2018 to November of 2023. There's only 12 more months in that look back period. So if you came to our office, we tell you to go ahead and self-pay for those 12 months. And then after that, whatever money's left would be protected. So let's say in a situation here, how can a trust really help you? Let's say Harry Smith had a home valued at $200,000 and he had $400,000 in assets. In 2012, he put his home into a $300,000 and $300,000 in a protector trust, the types of trusts we've been talking about. And he was admitted to a nursing home in November of 2018. So there's 6 years between 2012 and 2018, meaning that whatever money's left will be protected. So we see here in 2012, he spent $100,000 on personal expenses, but because he made it more than 5 years, he would be able to protect all that was there. So that's why in the best scenario, somebody puts their assets into a trust and waits 5 years. But if that doesn't work, we look at it in case-by-case situation. What happens if you don't set up a trust? So let's say that, again, John Smith had a house at $200,000 and he had $400,000 in assets and he didn't do any planning. What's going to happen in that situation is that he has that $600,000, the 200 plus the 400. He would only be able to retain $2,400 or $8,000, depending on his gross monthly income. So that whole $600,000 would be available for care. Now, when you go into a nursing home, they don't ask you for the $600,000. Like, you don't just send them a check. What happens is every month you get a bill for about $15,000, but all of you can appreciate how quickly that uses up the money. So even in 10 months, that's about $150,000 that would be used for nursing home care. And that's really important if we have a spouse and we don't know how much longer that spouse is going to live, or even if we go in for a short period of time and then we get better and we want to come home, we want to make sure that we've protected our assets in that situation. So when we think about this, when we consider setting up a trust, we've already talked about, helping to pay for care, but we also sometimes want to think about our children. And so, we want to give them inheritance. They've grown up, they're out of the house, but we worry about if I pass away and they receive the money, what happens if they get divorced? So a trust always also allows us to protect against that. So when should we consider setting up a trust? Well, if you have a family history of medical conditions that require long-term care. So medical history is really, really important, and we have to look at our own family histories. Or whether or not you have a family history, you just want to protect your real estate and assets from the cost of long-term care. In this situation, there's so many positives of pre-planning. There are, even if somebody doesn't make it through the whole 5 years, there's still a lot of things that can happen. But pre-planning always allows for more flexibility and puts you and your family in control. That's the best protection for any family rather than waiting for the crisis. So I do have a question that's come up. Somebody's spouse is 81. Should they just do a will, or should you set up the trust? At 81, I would definitely set up the trust. In our situation, love to know more about the person's health, but that's not too old to do a trust in any manner. And even if somebody doesn't need nursing home care, there's still value to having done the trust on the estate administration side. Okay. What to expect at our law office. So today we try to talk to you about trust and give you, really 3 tips that would allow you to start thinking about things, about how you would tailor it if you decide to tackle a trust in your estate planning. But at our office, there's a team of attorneys, certified Medicaid planners, and support staff that are knowledgeable about this. We all work together as a team. So you work with me and Megan and Tammy and Kylie and different people that are on teams, because we want everybody to have individualized planning. And we want to work with you so that you have quality of mind, peace of mind, and it's our job to make those quality documents. So also getting the question, should each spouse have their own trust or do a family trust? Usually we would just do one trust for husband and wife. That's another great question. So what are our clients saying about us? So this client saying that they're so glad that they found out about Steinbacher, Goodall, and Yurchak. A friend of a friend had used them and they came highly recommended. The mother was going into a nursing home and needed to find a way to pay for it. They listened to my concerns and worked out a viable plan, placing the assets into a trust. The annuity from the trust, along with the Social Security, pays the cost of the care, and couldn't have asked for a better solution. So that's what we love to do at our office, is help people who are in crisis and help people pre-plan ahead of time. So if you're worried about your own future and wondering about that, and you think it's time for you to take the steps to protect your future, we suggest that you schedule a long-term care strategy session. And this is a session where Megan would, or myself, or a long-term care planner would absolutely spend time talking to you about your individual situation. First, we'll look at your estate planning documents to make sure that they're in good order. And that's really important. Sometimes people have older documents that work well, and sometimes people have older documents that actually don't work well. And people need to know that. So it always makes me upset when people have, they've put together powers of attorneys, they cared enough to do these documents, but the law changed and now they didn't work, or they don't exactly understand how the powers that are in there work in their situation. So during this session, we always look at your documents, your older ones. We ask you to bring them in. We ask you to send them to us ahead of time. We talk about your situation and say, this is what they say. Is that what you wanted? And sometimes it is. And sometimes people say, oh, no, that's not what I wanted. We also would help develop a plan for your second half of life. So looking at your particular assets and your goals and your own health, like what is it that we can do today to help protect you? And of course, answer all of your questions about your own unique situation. At the end of our time together, you'll know what documents you need, and sometimes you'll know that your documents are okay, and that's just a great thing to know. You'll also know your options for long-term care. And most importantly to us, you'll have peace of mind knowing that you and your loved ones are ready for whatever tomorrow brings. And so if we have good decision makers, we have an unfortunate circumstance, it's easier to deal with that.
Hey, Julie,
Mhm.
questions then with fees. Are there ongoing costs or fees associated with a trust that our firm creates as we go along? Is there add-ons with that, or?
Yeah, that's a great question. For the majority of people, there are no additional fees. So at the end of the meeting, we would quote people a fee to set up their plan, but there aren't ongoing fees. When people think of that, they often think about using a trust service like at a bank where they take a percentage every year. That's if you don't have good decision makers in your own family, we need to do that. But at the other side of it, Kyle, I would like to say to everybody, lots of times people think they do it once and they never have to do it again or pay anything again. So although they're not ongoing fees, the fact is life can change. So I often say to people, you might pay an investment to get your affairs in order. And then maybe somebody gets sick and they're in a nursing home and there might be more that they have to pay. That could be 10 years later, or maybe down the road, somebody else passes away. And so there can be more fees, but it's not a yearly fee for that. We do not do it that way at our firm. So after the meeting, we develop a written plan with recommendations. We also work with you on implementing the plan. So if we want to put something in the trust, we want to fund it, we want to change beneficiaries, our office actually helps you do that. I know other law offices, they'll just do the legal documents and hand you the directions. And quite honestly, I feel like that's me like taking my car to the shop and they hand me the brakes and the directions on how to do it. Like, I don't know how to install that. I don't just need the brakes. You don't just need the trust. You need it set up correctly. And so we help you do that. Now, we do need your participation in it because a lot of companies can sometimes be difficult to work with. And so sometimes we need you to help us do it. It's not like we just wave a magic wand and it's done, but we're the ones that know how to do it. And so we walk with you along that journey and make sure it's done. Of course, we prepare any legal documents. So typically, the value of this type of a strategy session is about $495. But whenever somebody gets on these and listens to us, we find that you know a lot more and are more able to understand what it is you need to do. And so you can book a strategy session today at no cost for free. So what's the catch? Well, there's always a catch, right? In order to set that up, Kyle has put in the chat box, chatwithsgy.com. If you go on there, there are appointments available. And that's the catch. The catch is that there's only so many appointments available. We are quite busy at our office, but whenever we do these events, we always put some appointments there ready for people so that we can work with them. The other catch I would say to everybody, and this is just generally about this type of planning, is that it's your health that buys this. So the other catch is like you need to, it's not your money, it's not how much money you have, it's really your health. So this is something that we definitely want to do prior to you being sick, if at all possible. Now, if you're on here and you already have a diagnosis, you're already worried about something, don't be upset about that because there's always stuff that we can do, but the sooner we start, the better. So to book your strategy session, go to chatwithsgy.com and you actually can take and copy what Kyle put into the chat and open up a new browser and paste that in there and you'll be able to get on there. If you have questions, you can email at info@paeldercouncil.com, or you actually can call our office at 800-351-8334. Whatever feels most comfortable for you is really what we want you to be able to do. And when you do that, We'll also talk to you about how you want to meet with us and make sure you're comfortable. Our gift to you, anybody who wants what to really know at the second half of life, just email at the info@paeldercouncil.com or call 800-351-8334. And again, just in that email, ask for a free copy of the book, or when you call the office, ask for the free copy of that book, and they'll make sure that they send that out to you so you can learn even more about topics that are really important in planning for the second half of life. So again, to book your free strategy session, go on chatwithsgy.com, info@paeldercouncil.com, or call 800-351-8334. Again, the chatwithsgy.com, that is a URL. So you put that into, right now you could, on your Zoom, make it so that you are exiting the full screen. So you go up to view, exit full screen. You'll see that you can add another browser. There will be a little plus mark. Click on that, and then put in chatwithsgy.com. Or you can wait until after this. I'm just a quick start, so I like to do everything right away. So whatever makes you feel more comfortable. Now, I do see I have a question here. Are special needs trusts only revocable? Debbie, that's a great question. They actually can be revocable or irrevocable. We do them different ways depending on what we're trying to accomplish. And special needs trust can be first party, which means it's the person's money who has the disability. It also can be third party. That means it's a parent, a grandparent, some other third party that is trying to leave money to them. So remember, go ahead, Kyle.
I was just going to say another question I don't think we got is there any trust option to protect an IRA?
Oh, that's a great question. We typically would not take an IRA and put it into a trust because it would make it completely taxable. But when we do planning for husband and wife, we will make the trust a beneficiary. So my husband's name is Donald. So in our situation, his IRA, instead of it going outright to me, it would go into a trust that I could benefit from. And then what would happen is if I was sick when he died, it would protect it. For those people who already have a diagnosis, who we know may be on their way to going to a nursing home, we might cash out the IRA and put it into a trust. For those of you who are healthy and you're just worried about this, we then would look into creative financial solutions with the help of a financial advisor, because there's actually some really good options there. Our role in that is as the attorney, the tax advisor, understanding how that works within your overall plan. There are some really good asset-based long-term care strategies that can be helpful. So that's actually, the question's a great one because it's like the hard one for us because it's not as simple in that situation, but there are ways that we can work around that. So remember, you'll have an estate and long-term care plan that's updated with current laws when you meet with us. You'll know your payment options for long-term care and how your assets are protected from financial devastation. And I think the most important is just having peace of mind, knowing that you and your loved ones are better prepared for the challenges of tomorrow, and also knowing that you're not leaving a mess to your children, which is really important. So again, if you're interested in a long-term care strategy session, go to chat with SGY or email info@PA or simply call our office at 800-351-8334. However it feels most comfortable for you to be able to do that. We're happy with any of those methods. Megan and I were really happy to be able to spend some of our afternoon with you. I think this is a really important topic to get to know and understand a little bit more about trust. I also know that sometimes on these events, we have clients who are here who are relearning about their documents and their trust. We also want to let you know that you're always welcome to make an appointment and talk to us about what you learned today, and just to get your own reassurance that what you're doing and what you set up really works for you, because we hear it differently at different times in our life. And so I always want everybody to know we're always open to meeting with people who've already done this and just want to review, because I think that's important, especially if maybe we want some kids involved. So very much. Megan, any parting thoughts from you?
Not at this time, but again, I'm just so thankful for all of you who are taking time out of your day, and we're looking forward to helping you in the future create your estate plan the best way for you and your family.